right, sir. Thank you so much for speaking with us, sir. President Tinubu's decision to suspend Governor Fubara and other elected officials in River State has been described as unconstitutional by many legal luminaries, including yourself, sir. He justified the emergency, the state of emergency, by citing legislative deadlock and security threats. In your legal opinion, sir, does the Constitution provide any justification for such an action, or could this be considered an overreach of federal power, sir?
Well, by virtue of Section 305 of the Constitution, the governor of a state is empowered to request the president to impose a state of emergency. And if the governor does not do so, the president may impose a state of emergency. Once it is declared, the president is required to approach the National Assembly for endorsement within 48 hours. And the request must be supported by not less than 2/3 majority of the two houses of the National Assembly. If it is approved, the president is empowered by the Constitution to adopt extraordinary measures to restore law and order. In other words, the president can increase military presence or police presence in the state and take other steps that can guarantee or restore law and order. The Constitution, the drafters of the Constitution had envisaged that there may be situations where the State House of Assembly may not be able to sit for one reason or the other. Again, the Constitution has made provision for that. In other words, by virtue of Section 11, subsection 4 of the Constitution, the National Assembly is vested with the power to take over the legislative functions of the House of Assembly that is unable to function. So, if the crisis in River State had to do with the confession in the House of Assembly, right? It didn't warrant a state of emergency. Secondly, for reasons best known to the Supreme Court, it decided that those who are defected should take over the leadership of the House, and that the governor of the state should present his budget before the House. That order was yet to be complied with when a state of emergency was declared on the state. Section 11, subsection 4 emphatically provides, there is a proviso there, which states in clear terms that the taking over of the functions of the House of Assembly shall not lead to the removal of the governor and the deputy governor of that state. Yes.
Sir, given that the Supreme Court reportedly declared the Rivers government dysfunctional, does that provide a strong enough legal basis for federal intervention, sir?
The Supreme Court had on its own taken care by saying the House should be reconstituted. And the governor, in line with Governor Fubara, in line with the judgment of the Supreme Court, had requested the House to allow him to present the budget. Yes. So the question of a dysfunctional government was already, taken care of by the Supreme Court.
There have been references that have been made to the emergency rule imposed on Plateau and Ekiti State under President Obasanjo. How does this situation compare legally and politically, sir?
You see, in the case of Plateau, there were civil disturbances, which, according to President Obasanjo at the material time, led to the declaration of a state of emergency. But what we did say then, and what we are saying now, that there is no provision of the Constitution that empowers the President of the Republic to hide under emergency rule to suspend an elected governor, an elected deputy governor, and elected legislators. There are pronouncements of the court on when a governor can vacate his office on account of resignation, death, impeachment, or ill health. So there can be no other situation whereby a governor can be removed, because the express mention of one thing is the exclusion of another. So the law is very clear, and the law has specifically enumerated the conditions under which a governor can vacate his office.
Now, sir,
an emergency rule is not one of them.
That's no doubt about it. Now, if the Supreme Court had previously avoided ruling in
the case of Ekiti, President Obasanjo claimed there were rival claims by the deputy governor and the Speaker of the House of Assembly. Again, those are matters that have to be resolved in a court of law. In the case of Rivers State, the dispute over the defection of 27 legislators is before the Federal High Court in Port Harcourt. I think the case is adjourned to the 20th of April. But for reasons best known to the Supreme Court, it took over the case and made this pronouncement.
President, sir, if the Supreme Court had avoided ruling on similar cases due to procedural issues, just like you have analyzed, what legal strategies should be employed now?
No. Those who may,
in order to get a substantive,
those who may be aggrieved,
yes, sir,
and who may want to approach the court, will have to study the cases of Attorney General of Plateau State and the Attorney General of the Federation, as well as the Attorney General of Ekiti State and the Attorney General of the Federation. In both cases, the Supreme Court held that those who filed the actions didn't obtain the authority of the administrators whose appointments were being challenged, and are therefore the attorney general that filed, the attorneys general that who filed the two cases are no longer standard. But with profound respect, the governor was removed, right? Or the governors were removed. The democratic structures, or rather, the governor was suspended, the governors were suspended, democratic structures were suspended, right? The office of the attorney general was not abolished, right? But again, that was the decision of the Supreme Court. So whoever may want to challenge the action of the president in respect of the imposition of emergency rule or declaration of emergency will have to study both cases and ensure that the question of local standard is taken care of.
The courts have reportedly fast-tracked cases benefiting Wike's allies while delaying rulings on the defection of the 27 lawmakers. What does this tell us about the impartiality of the judiciary in Nigeria, sir?
No, I don't think it will be fair to reduce the matter to the cases filed by Mr. Wike's sympathizers. We are worried in the legal profession that the Constitution and the management of our courts have as it were created a situation where political cases are fast-tracked. For instance, by virtue of Section 285 of the Constitution, governorship election cases shall be determined within 180 days. Any appeal arising from the decision of the Election Petition Tribunal shall be determined by the Court of Appeal within a period of 60 days. If the matter goes to the Supreme Court, also within a period of 60 days, altogether 10 months. With respect to presidential election disputes, legislative election disputes, they shall be determined again within 180 days. Appeals arising from them within 2 months. So altogether 8 months. Last year, the federal government filed an action in the Supreme Court challenging the dissolution of local governments by state governors, appointment of caretaker committees or sole administrators, as well as the diversion of the statutory allocations belonging to local governments. Within a period of 47 days, judgment was delivered by the Supreme Court. The controversial cases of Rivers State, the appeals were filed in December. Judgments were delivered in February. It's about 64 days interval. Definitely, the courts will have to review his position. And that's also what goes on in the Federal Court, in the Court of Appeal. Political cases are given priority over fundamental right cases, over criminal cases. Today, there are citizens on death row whose appeals have been pending for the past 10, 15 years. So the current situation challenges the system to ensure that the principle of equality before the law is practicalized.
So, sir, if I may ask, what legal avenues are available for a governor for Fubara, for example, if he believes that these interventions are politically motivated?
I would not want to engage in speculations. I think such a question should be directed to the governor. I cannot answer for him, right? I can only look at our experience under the 1999 Constitution. By the way, on one occasion, President Obasanjo publicly threatened to impose a state of emergency on Lagos. At the material time, the governor of the state, the current president, Asiwaju Bola Ahmed Tinubu, he made it clear and loud that if the president ever imposes a state of emergency on Lagos, the democratic experiment will be derailed. That was in 2000. In 2005, President Obasanjo even went to the extent of getting the permission of the National Assembly in advance to declare a state of emergency in Lagos. Again, Governor Bola Tinubu made it clear to him and the National Assembly that Lagosians will not accept it. So, some of our colleagues have not appreciated the fact that we're operating a presidential system of government, not parliamentary system. Under the parliamentary system, there was a law, right?
Yeah.
Emergency Act of 1962, made pursuant to the 1960 Constitution, that empower Parliament, right, to pass a resolution for a declaration of a state of emergency in any region. It was done in the case of the Southwest, and that led to a serious political crisis, which was partly responsible for the collapse of the First Republic. There was an attempt in 2018 to reenact the Emergency Act. But the National Assembly members were made to appreciate that we're operating a presidential system of government, which does not allow the removal of an elected person, an elected official. The United States of America has imposed about 1,000 760 national emergencies on no occasion as a mayor be removed by the president, not to talk of a governor. Under the current democratic dispensation, the governor of a state cannot remove an elected chairman or an elected councillor, and that the appointment of sole administrators or caretaker committees to manage local governments in the country, local government councils, is unknown to law. And that if any state, if any governor dissolves or removes democratically elected local government councils, the central bank and the accountant general's office should withhold the funds of the state until the statutory allocations of the local government, until the elected officials are reinstated. Again, there are not less than 10 cases, 8 by the Federal High Court, 1 by the Court of Appeal, and 1 by the Supreme Court, where it has been decided that a legislator, an elected parliamentarian, cannot be suspended or removed during the 4-year tenure. Because when you do that, according to the courts, you have particularly the case of Speaker Bauchi House of Assembly against Honorable Dana. Now, if you cannot remove a councillor who has been elected, an elected councillor, if you cannot remove an elected chairman of a council, you cannot remove an elected legislator. Under what provision of the Constitution can anybody justify the removal of or suspension of an elected governor, or the suspension of elected legislators, contrary to the clear pronouncements of the courts? For me, I think that, yes, some of my colleagues have said, yes, under Section 305, the president has inherent powers.
Yeah.
Once he has declared a state of emergency, extraordinary measures could include the suspension of all democratic structure. I beg your pardon. The Supreme Court has decided again, in one of the cases of Attorney General of Abia State and the Attorney General of the Federation, that only the courts are empowered by the Constitution to exercise inherent powers, and that neither the executive nor the legislature
Have the power.
is empowered by the Constitution to exercise inherent powers.
powers.
All their powers are stipulated in the Constitution and other relevant laws. So that is the position today.
Sir, let's look at the security concerns. President Tinubu had cited militant activities, pipeline vandalization, as part of the justification for the emergency rule. How valid are these concerns, and could they be addressed through normal security measures instead of imposition of this state of emergency?
Again, I do not have security reports that could make me justify emergency. But as I said, the powers of the president to adopt extraordinary measures to restore law and order in any part of the country, those powers do not include suspending the government. In fact, the president is required to collaborate with the governor and the democratic structures in ensuring that there is law and order. By the way, in 2013, President Goodluck Jonathan imposed a state of emergency in Adamawa State, Borno State, and Yobe State. And the president was under tremendous pressure from anti-democratic forces to suspend the governors and other democratic structures in those three states. Again, some of us publicly advised the president not to succumb to the prayers of enemies of democracy, that there is no provision in the Constitution for the suspension or removal of elected officials. Again, I think in 2021, the then Attorney General of the country, Mr. Abubakar Malami, announced that the government might impose a state of emergency in Anambra State because of the activities of some government.
State actors.
Again, we pointed out it's the duty of the government to arrest officials government and prosecute them. But you cannot hold the governor vicariously liable. More so that he doesn't control the security apparatus in the state. And if for any reason you declare a state of emergency to enable the president to adopt extraordinary measures, it will not include the suspension of the governor and the legislature in the state. Again, the government listened to wise counsel. Of course, even without declaring a state of emergency in the entire eastern part of the country, security was increased.
So, sir, how does this federal executive intervention impact Nigeria's federal structure, so to speak? And is this a step towards centralization of power?
No, you see, it has to be realized that we are operating a federal system of government. Some of the crises of security crisis in the country, the governors have themselves to blame for allowing the president of the country, successive presidents since 1999, to single-handedly exercise police powers under Section 216 of the Constitution. The president cannot remove or appoint an Inspector General of Police without consultation, without consulting the Nigerian Police Council. Who are the members of the Nigerian Police Council? The president is the chairman. You have the Inspector General of Police, the chairman of Police Service Commission, and the 36 state governors. In that federal executive body, you have 3 officials of the federal government, and 36 state governors. What are the functions of the body? Of course, like I said, to advise the president on the appointment or removal of the Inspector General of Police. More importantly, that body shall organize, administer, and supervise the Nigerian police force. The body is required to meet regularly, just like National Defense and Security Council and other federal executive bodies. But the body never meets. In fact, there was a time I had to go to court to compel the federal government or the governor to requisition a meeting of the body to discuss the worsening security situation in the country at the time. If while the case was in court, the National Assembly passed the Police Establishment Act of 2020. I think Section 6 there provides that the police council, Nigerian Police Council, shall meet at least twice a year. So if the governors have been sharing police powers with the President of the Republic, if the governors have jointly with the federal government, with the President, Inspector General of Police, and the Police Service Commission, jointly organized, administered, and supervised the Nigerian police force, the security situation in the country will not be as stable as it is. So when you talk of reasons for a state of emergency, there will always be problems. Terrorist attacks by bandits, kidnappers, armed robbers, gunmen, and so on and so forth, that may overwhelm a state or states. But if on every given occasion that a state is overwhelmed, you suspend the democratic structures, you are making a mockery of democracy. By the way, Section 305 also provides that the president may declare a state of emergency in the entire country. It can impose emergency rule on the entire country. Say, for instance, we are fighting a war with a neighboring country or neighboring countries. So if the president declares a state of emergency in the entire country, would the National Assembly remove the president and appoint a sole administrator to run the country? No.
So we're aware that you were out of the country at the time when this state of emergency was imposed on the River State, and we tried to reach you during that period. What's the impact of this presidential declaration on West African countries, the West African countries, considering the president's actions in this regard, sir?
I was actually attending a meeting of the Media Foundation for West Africa as a board member in Dakar, Senegal last week. And it's a francophone country. And so while we were at the meeting, a message came that there was a crisis in Nigeria. And we were told that there was a coup in Nigeria. Of course, I rushed out of the venue of the meeting to listen to the news. And of course, I confirmed that a state of emergency had been imposed in River State, of course, democratic structures suspended, the governor suspended. So I rushed back to the venue to inform my colleagues that it was not a military rule, but that, emergency rule was imposed on a particular state. And they then asked me, yes, how can you remove an elected governor? How can you remove elected legislators? And what is the justification for having, they thought it was a military administrator. Again, I had to announce that. I had to clarify. And it's a retired naval officer. It took time to convince them. And of course, we had discussed constitutional change of government in Africa, particularly in West Africa, and I had made a presentation the previous day, and we then had to review my presentation again on how to strengthen the democratic structures in the sub-region. And it has never been so bad. And because Nigeria is expected to show leadership in the sub-region, the embarrassment was colossal. More so that President Bola Tinubu is the current chair of the ECOWAS. So to whom much is given, much is expected. And I do hope that Nigeria will move speedily to put this matter behind it. We have no choice. Because right now, democracy is in a serious crisis in the sub-region. 4 countries are under military dictators. The Gambia, President Adama Barrow is planning a 3rd term. In Côte d'Ivoire, President Alassane Ouattara is planning a 4th term. In Togo, Gnassingbé Eyadema is spending a 5th term and planning a 6th term. Frankly speaking, apart from Ghana and Senegal that hasn't had a military coup since its independence in the 60s, we have a long way to go in putting a constitutional change of government behind us. And from what we have, from the political dictionary now, in Africa, it is no longer when you have a coup that you talk of a constitutional change of government. That is what has just happened in River State.
Under the present circumstances, when Nigerians feel that injustice has been done by a democratically elected government, is there nothing they can do to correct such illegalities? As it seems Nigerians are now powerless under a democracy.
No, Nigerians can't.
Like a military.
No, Nigerians are not powerless. What threats to democracy requires on the part of the people is to get organized. Because people are organized, they can never be defeated by dictators. And morally, it's difficult for President Bola Tinubu. Morally, very difficult for him to impose dictatorship on the country because of his own role in the past. It's very difficult. Very difficult. And that is why the president is being confronted with his own record. And you know, the internet never forgets. While I was in Dakar, before even making a statement, people brought out what I said when a state of emergency was imposed in Ekiti State, in Plateau State, even in 2013. So I was flabbergasted, So, but for me, the beauty of it is that I was being told that, yes, when this happened in the past, this was your position. The statement by President Tinubu, the condemnation by President Tinubu, when emergency rule was imposed on Plateau State, was brought out. His statement in 2013, when President Jonathan imposed a state of emergency in the northeast region, was published, was reproduced. So, and that's what I mean by saying that it's a moral crisis. And for me, the president has to go back to the drawing table and look at the mirror. Can I afford to be associated with undemocratic practices, having regards to my position in the past, when you have situations of this nature? That's what you call consistency. But the history of Nigeria is that no dictator can defeat the people. We defeat military dictators. Nigeria defeated colonial dictators. So civilian dictators can never succeed in Nigeria.
Sir, in your view, what is the most legally sound way to resolve the River State crisis without undermining our democracy?
Again, as I said, in the case of Attorney General of Lagos State and Attorney General of the Federation over the seizure of local government funds, the Supreme Court made a point that the action of the President Obasanjo, was totalitarian, and that totalitarianism is alien in a democratic country, and that the governments must never believe that the court process is too slow. Therefore, we engage in self-help. That the government must learn to approach the court to resolve crises. In like manner, aggrieved citizens must not take the law into their hands. They can either approach the court or embark on political measures to influence the decision of the government, to compel the government to reverse its decisions. Hence, we have fought and won the battle for Nigerians to protest peacefully without asking for permission or police permit. That was the culture in the past since the colonial regime, because the colonial regime believed that, no, why should we allow Africans to demonstrate against us without giving them police permit, which of course they will never give. Those who took over the reins of power in 1960 retained the entire instrument of oppression. And one government after the other retained the police permit as a precondition for organizing protests in the country. But we successfully challenged it. and won in 2006. The government went to the Court of Appeal. We won in 2008. And so, under the current Police Establishment Act, Section 83, subsection 4, during protest, the police shall provide security for the protesters. That is here to sink, because protesters are still blackmailed and they're harassed and tear gassed, So, but Nigerians have the right to protest for or against the government. Nigerians have the right to approach the court for legal redress. Nigerians have the right to engage in civil disobedience, and so on and so forth.
Is there any way outlined in law by which assemblies can punish lawmakers for misconduct? And what is the legal way by which assemblies can punish lawmakers when there is even a clear case of misconduct, sir?
Well, any country that operates under the rule of law will have to study the judgments of court and perhaps amend the law or the Constitution if there is a lacuna. In 2010, about 11 legislators were suspended by the House of Reps. It was under Speaker Dimeji Bankole. So in the case of Dino Melaye and others, the Federal High Court declared the suspension illegal on the ground that it was beyond 14 days. I handled the case. In the case of Honorable Gibril against the Dogara-led House of Reps, the Federal High Court declared illegal the 180 days suspension slammed on him. In the case of Honorable Dana against the Bauchi State House of Assembly, the court declared an indefinite suspension illegal. She was the only woman in a 31-member House of Assembly and the only Christian. So our male colleagues felt embarrassed and insulted that she had the temerity to criticize them in the House. So, of course, the matter went on appeal, and the Court of Appeal took its time to make fundamental pronouncement. One, that you cannot suspend a legislator who has been elected. Two, you cannot seize, cannot confiscate his or her salary. Three, that when you suspend, you also violate the rights of the constituency, the members of the constituency that elected, and that separately, the members of the constituency can take action, can file an action against the House or the Senate. Again, as I said, I handle those cases. My colleague, Mr. G.S. Okuchepa, SCN, handled the case of Elder Sani against the Kogi House of Assembly up to the Supreme Court, where again it was said that you have no power to suspend the legislator. The Court of Appeal in Ondo State, the State High Court have ruled against the suspension of legislators. In Edo State, the National Industrial Court has ruled against the suspension of legislators, and there are about 2 other cases. In the case of Senator Ndume against the Senate under the Bukola Saraki-led Senate, the Federal Court said it was illegal to suspend a legislator. In the case of Senator Omar Agege and the Senate, Bukola-led Senate, the Federal Court also annulled his suspension.
There are judicial pronouncements on this matter.
In the case of Senator Ninge, he was suspended. He briefed us. We were in the process of filing the action in court when he was recalled by the Senate. So there are cases over 10. And so you do not expect the Senate, led by a senior lawyer, in the person of Senator Godswill Akpabio, to have engaged in the impunity of suspending Senator Natasha Akpotudua. But you know the attitude of public officers in Nigeria now. When you remind them, what you are doing is illegal, they say, yes, it doesn't matter. Let her go to court before our fate is decided. We'll have achieved our objective. And in any case, the actions will be defended from the public treasury. So impunity continues because there is no accountability and there is no sanction for impunity. That's why we're in a mess. People rig election and they say, go to court. Of the ruling class engage in such either executive recklessness or legislative rascality. You are inciting the people to take the law into their hands. Because today, the court is no longer the last hope of the common man. It has become the last hope of the politician. And it's a dangerous situation in which we have found ourselves. But for those of us who are also involved in campaign for the socialist reconstruction of our country, I'm not worried. If members of the ruling class have decided to collapse their own system, so be it. Yes.
Still on Senator Natasha, INEC has said it has received petitions to recall her and will proceed to verify the signatures. Meanwhile, there was a court judgment barring INEC from accepting such petitions in the interim. Why is no one, including prominent voices, talking about this? You have not even spoken about it.
No, the court has reversed itself. And the judge has been compelled to withdraw from handling the case. For reasons, that may be disclosed later. But the recall exercise is bound to fail.
Why do you say so?
It's dead on arrival. When the list of voters for the recall was submitted to INEC, it was discovered that there were no addresses, there were no contacts. So the question of verifying the genuineness of the list, was problematic. It was claimed by an organization that the addresses have been supplied. Again, another organization. The first organization said, we are Kogi Central Political Frontiers. Another organization concern Kogi youths and women. There's no provision for any organization to submit the list or provide addresses. It's the business of the voters and INEC. 2, those 2 organizations are not registered with the Corporate Affairs Commission. That has been confirmed. So whichever way they run, they are bound to be disqualified. It's a Herculean task to recall a legislator in Nigeria under the current democratic dispensation. They claim that about 250,000 people and voters signed up for her recall, whereas only 103,000 or thereabout voted for all the candidates that contested the senatorial seat. So we are watching. But I think INEC should have, by now, reached a conclusion that there's no point continuing with this exercise.
Finally, sir, to be remiss if I do not ask this question. A young core member recently trended when she criticized President Tinubu. This generated arguments online as some people believe that as a core member, she had no right to do so. What is truly the position of the law regarding this?
Again, in the case of Otonwanko and the state, the Court of Appeal made the point. I'm talking, this case was decided in 1982. Yes. The late Justice Olajide Olatawura made the point that under a democratic dispensation, criticism is indispensable, and that public officers who feel too irascible should plug their ears with cotton wool. In that case, his lordship said that the freedom gained from our colonial master must not be allowed to be toyed with or sacrificed by any government. Those epochal statements cannot be dismissed by any democratic government in Nigeria. It's even an area that I blame the press, and I was talking to a comrade of mine, Larry Arogundade, a leader, of the media in Nigeria. That come. Why are you allowing the police to continue to harass journalists under the Cyber Crimes Act for defamation, annoyance, cyber stalking, and the rest of them, when the law has since February last year been amended by the amendment of Section 24, based on 2 decisions of the ECOWAS Court, one by Serap and another one by a group of lawyers. That section now has been amended to the extent that what is now criminalized is using the computer to send pornographic materials or a message that contains a threat to life. That's nothing to do with defamation. Now you have annoyed a big man, or you have engaged in cyber stalking or whatever. The law is now saying, sue for libel or slander if you are defamed. So, the youth corps member was enjoying a freedom of expression, which is guaranteed, freedom of expression, guaranteed by Section 39 of the Constitution and Article 9 of the African Charter on Human and People's Rights Act.